Andrew and Tristan Tate just suffered another loss in court. This time, it's in Palm Beach County State Court regarding a defamation action they filed against those who accused them of serious crimes. But now it's backfiring against them. Let's discuss. I'm Dave Ehrenberg, former state attorney for Palm Beach County, aka the Florida Lawman. Thanks for your support. Hit the subscribe button if you haven't done so already. This is a self-own. The Tate brothers walk right into this one because for years their playbook had been simple. They have filed aggressive defamation lawsuits against them and dominated the narrative online. But Circuit Court Judge Joseph Curley just handed down a major win for the defendants who have turned into counter plaintiffs. They're in turn suing the Tate brothers, and they want documents and information from them. And the Tate's saying, no, you're not entitled to it. And then they responded to their interrogatories with just basic responses. And now Judge Hurley said, not good enough. He's ruled for the defendants, who are now the counter plaintiffs, and have ordered the Tate brothers to hand over their financial books, their bank statements, their webcam records, and internal operations of Hustlers University and the War Room. Remember, this is where they give their PhDs, pimp and hose degree. Yeah, this is a big mistake they made in filing these lawsuits because it's going to create another problem for them as they try to fight their criminal charges and the extradition back to the UK in the criminal matter. So let's get into it. The background of this one is that back in July 2023, while they're facing criminal investigations in Romania, the Tate brothers went on the offensive. They filed a massive civil defamation lawsuit in Palm Beach County, Florida, my neck of the woods, against an American woman known as Jane Doe and others who had spoken out to law enforcement. The Tates claimed that Jane Doe's statements to authorities were false and that her allegations single-handedly destroyed their global brand. But the problem with filing such a lawsuit is the discovery process. When you sue someone for hundreds of millions of dollars in damages, the American civil justice system gives the defendant broad rights to say, prove it. Show us your financial records. Show us your contracts and communications. And the Tates did not want to do that. In sworn interrogatory responses, they claimed that it was $348 million that they lost in commercial opportunities and brand damage, plus another $12 million in seized luxury vehicles, jewelry, and assets in Romania. So they put it at $30 million for a 3-year TV production agreement, $77 million in lost world tour and promotional revenue, $45 million in major streaming platform deals, $40 million in top-tier brand partnerships, $25 million in lost digital assets and investment opportunities, and $40 million in permanent impairment to their brand goodwill. They claimed over $1/3 billion in harm. But when Jane Doe's lawyers asked for the contracts, the tax returns, the profit and loss statements, and the mathematical calculations behind those figures, the Tates produced nada. Nothing. Not a single supporting financial sheet, not a single canceled contract, not a single document showing the corporate structure behind their enterprise. Instead of proof, they filed what's called boilerplate copy-paste objections. They responded to the requests for the specifics with responses. That's an overbroad request. It's vague. It's unduly burdensome. It's proprietary or an invasive fishing expedition. This happens a lot in litigation. A lot of lawyers do this, to be fair. This is pretty common, but it's up to the judge to say, you're hiding behind these broad terms. If you're going to say you lost all this money in damages, if you're going to be the one to file a lawsuit, you're going to have to come up with the goods. Tell us where you got this $1/3 billion from instead of just random numbers. And Jane Doe's lawyers asked for their internal text messages and communications about her. And the response was, Jane Doe should already have this information. She's asking us to do her discovery for her. It's not how civil litigation works in the United States. When Jane Doe asked for details regarding the physical and psychological harm that Andrew and Tristan Tate suffered during their Romanian detention, Andrew gave a narrative describing his time in what he called a cockroach-infested dungeon Sounds familiar to what he's describing now in Miami, right? He claimed he maintained the mental discipline to help other inmates. And yet, when he's been asked for the medical records, the psychiatric evaluations, or treatment notes to substantiate those claimed damages, their formal response was the information was being accumulated and they refused to provide it. So Jane Doe's legal team filed a comprehensive motion to compel. They argued that the Tates can't use the Florida courts as a sword to demand hundreds of millions of dollars in damages while using boilerplate objections as a shield to hide the reality of their business operations. It was up to Judge Curley, and he dropped the hammer. He gave a very strong order just the other day, which was a total across-the-board defeat for the Tate brothers. We'll go through what he ruled. Number one, he ruled that the boilerplate objections are overruled. He struck down every single generalized and boilerplate objection raised by the Tate brothers. He said the privilege claims are overruled. Their blanket claims of proprietary business information and unparticularized privilege were dismissed. So if you want to withhold something under attorney-client privilege, he said you have to prepare an itemized privilege log. You can't just say it's all covered by attorney-client privilege. You got to be more specific. And then he granted Jane Doe's motion to compel on virtually every key interrogatory and request for production. I mean, that means all social media platforms, private messaging channels, like Signal, Telegram, WhatsApp, and public broadcasts where they discuss Jane Doe, you got to turn it over. Every detail regarding their webcam platforms, how they recruited models, the identities of the women whose webcam earnings they took cuts from since January 2021, and all banking and merchant account information tied to those operations, the ownership structure, the internal communications and form records from Hustlers University, the Real World, and the War Room, and full bank statements, accounting logs, and evidence supporting every single dime of that claimed $348 million loss. And the court ordered the Tate brothers to produce all of this within 30 days. And within that order, there's paragraph 15. Let's look at paragraph 15. Failure to comply with this order may result in sanctions, including attorney's fees, dismissal of certain claims, and or costs assessed. So, does this matter beyond the civil defamation claim? Does it matter for their extradition proceedings, their international trial? Well, it kind of does, because in Romania, they're facing the ongoing indictments and the second phase investigations there involving human trafficking, organized crime, trafficking of minors, money laundering. More importantly, in the UK, they're wanted for extradition. They're being sought for extradition because they're facing serious charges that could put them in prison for the rest of their life. Charges involving sex trafficking and sexual assault and child pornography. It's really ugly. Now, Judge Curley here is ordering them to disclose their bank statements and corporate structures and all these other things under penalty of perjury. They've got to disclose it. So there's a trap here. Number one, option A, they comply with Judge Curley's order. They produce the unredacted bank accounts, the financial data, and all the other communications. And that, of course, helps Jane Doe's case. And the documents could reveal the exact financial and organizational structure that European prosecutors have spent years investigating. Or option B, they refuse to comply, or they invoke their Fifth Amendment right against self-incrimination. But when you plead the Fifth in civil litigation, the judge and the jury are allowed to draw an adverse inference against you. In criminal law, you can claim the Fifth and it can't be used against you. Not in the civil world. If they produce their financial records, that could hurt them in their criminal trials. And if they don't, then their entire $348 million defamation claim can be thrown out with prejudice, meaning they can't file it again. And even worse for them, because Jane Doe has filed the counterclaims against them, they could lose that as a result and have to pay hundreds of millions of dollars in damages to Jane Doe. I mean, she's filed civil counterclaims against them for sex trafficking, for defamation. So stalling along the court order could lead to a default judgment against them and a massive payout. So the clock is ticking. The Tate brothers have 30 days from the entry of this order to turn over the exact financial and operational blueprints of their empire. And they're the ones who brought this lawsuit, and now it looks like they're paying the price. This is the kind of thing that may have sounded good at the time for them, but in the end, it's coming back to haunt them. It's backfiring, just like their whole persona is backfiring against them in Miami in their extradition case. And we'll keep following it here on Substack and YouTube. I'm Dave Ehrenberg, a.k.a. the Florida Lawman. If you like this video, hit the like